Well, good morning. I am so happy to be here, and I want to thank End of Life Ireland and the World Federation of Right to Die Societies for bringing us all together for this wonderful, wonderful conference. I've learned a lot already, and I'm looking forward to learning even more throughout the rest of today. I'm going to talk about medical assistance in dying in Canada and our values-based, human rights-driven journey to legalization. In a nod to Ireland's storied love of poetry, I thought I'd give my outline of my talk in verse, with apologies to all Irish poets. I keep 6 honest men. They taught me all I knew. Their names are what and why and when and how and where and who. So first to the where. Well, obviously Canada. But I have to give you a caveat, which is that there's one province in Canada, and that's Quebec, that has been on its own MAiD journey. And I don't have time to describe it in my talk, but I'm absolutely happy to answer questions on it. Catch me at any break. So now as to the why. Well, I'd say Canada's MAiD journey has been values-based and human rights-driven. The values underpinning our MAiD regime are life, autonomy, dignity, equality, relief of suffering, freedom of religion and conscience, and protection of vulnerable people. And the rights serving our values are the right to life, liberty, security of the person, equality, and freedom of religion and conscience. And I should emphasize that those rights in Canada are constitutional rights. So what about the how? Well, the vehicles for our journey have been the courts and Parliament. So we have the Carter and the Truchon cases from the courts, and we have bills C-14, 7, 39, 62 from Parliament. Now our journey can best be described as 5 steps forward, 3 steps back, 3 steps forward, 1 step back, somewhat exhausting, but nonetheless forward moving. On February 6th of 2015, the Supreme Court of Canada, our highest court, found that the Canadian Criminal Code blanket prohibitions on MAiD violated the Canadian Charter of Rights and Freedoms, and they struck them down for persons with a grievous and irremediable medical condition causing enduring and intolerable suffering. In response to the Supreme Court of Canada decision in Carter, the federal parliament passed Bill C-14. Unexpectedly, the bill narrowed eligibility by requiring that in order to be eligible for MAiD, a person's natural death had to have become reasonably foreseeable. Then in response to Bill C-14, 2 individuals, Nicole Gladu and Jean Truchon, they had severe disabilities and they were thus excluded from eligibility by the natural death has become reasonably foreseeable criterion. They launched a charter challenge to that criterion. And Justice Baudouin of the Quebec Superior Court declared that the criterion breached the charter, and so she declared the NDRF criterion to be of no force or effect. But in response to the Quebec Superior Court decision in Truchon, the federal parliament passed Bill C-7. It removed the eligibility criterion of natural death has become reasonably foreseeable, but it unexpectedly introduced an exclusion, a temporary exclusion from eligibility for persons with mental illness as their sole underlying medical condition. The exclusion provision was supposed to automatically be repealed 2 years after the coming into force of Bill C-7. However, in March of 23, Parliament passed Bill C-39, which extended the life of the exclusion for an additional year. And then in February of 24, Parliament passed C-62, extending the life of the exclusion for an additional 3 years, so to March of 2027. So that's how we got to where we are. Let's turn now to what we actually have now, both in terms of law and practice. So first, in terms of law. Well, there are 2 types of MAiD in Canada. Provider-administered MAiD is when a clinician administers drugs at the person's request that cause the person's death. And self-administered MAiD is when a clinician prescribes drugs to a person at their request so that they may self-administer those drugs and in doing so cause their own death. Both physicians and nurse practitioners in Canada can assess and provide MAiD. To be eligible for MAiD, you have to be eligible for government-funded health services, be at least 18 years of age, be capable of making decisions with respect to your health, have made a voluntary request for MAiD, and have given informed consent to receive MAiD. And you have to have a grievous and irremediable medical condition. This is defined in our criminal code. You have to have a serious and incurable illness, disease, or disability, be in an advanced state of irreversible decline in capability, and the illness, disease, or disability, or the advanced state of decline must be causing enduring and intolerable suffering that can be physical or psychological, and it's suffering that cannot be relieved by means acceptable to the person. Note, remember, mental illness is not a serious and incurable illness, disease, or disability under this law. So people with mental illness as their sole underlying medical condition are at this point excluded from access to MAiD. This will supposedly be automatically repealed in March of 2027, but don't hold your breath. I just want to emphasize here, as should be obvious, you do not have to be terminally ill in Canada. There's no 6-month prognosis limit, no 12-month prognosis limit. There's no prognosis limit in Canada. Now, what about procedural safeguards? Given time constraints, I'm actually not going to review all of the procedural safeguards today. I just want to note that they establish robust requirements for eligibility assessments, witnessing, the provision of information, consultation with experts, and so on. I'm happy to answer questions in breaks about the procedural safeguards. But I decided to strip out the procedural safeguards because I wanted to buy some time to cover a few issues that came up yesterday, to offer up the Canadian approach to them. And I hope by doing this to show you how to avoid adopting barriers to access which are masquerading as protective measures. So we're going to talk about raising MAiD, time between the assessment, request, and provision, the pre-approval and review by a committee or a board, and MAiD provision after the loss of capacity. So first on raising MAiD, we view this through the lens of informed consent within a clinician-patient relationship. So if you are, as clinician, discussing end-of-life options with someone, you have a duty to inform them of all of their options. And if the person might be eligible for MAiD, then MAiD is an option. Therefore, if they might be eligible for MAiD, you have a duty to inform them about MAiD. Time to provision. We originally had a 10-day period between the request being signed to the provision of MAiD. There was an enormous amount of feedback from patients and clinicians that this was a barrier to access without any protective effect. And we actually got change in our law. So now, if natural death has become reasonably foreseeable, there is no time requirement. If natural death is not yet reasonably foreseeable, then there is a 90-day wait from the start of the first assessment until the provision. However, that can be waived if loss of capacity is imminent, and then it is whatever time period that the clinician deems to be appropriate. Pre-approval review by a committee or a board, we see this in some jurisdictions. We see that as a prolongation of suffering and a barrier to access. This was expressly rejected by our Parliament, and eligibility is entirely determined by the two clinicians. Now, what about MAiD provision after the loss of capacity? We have a rule that is immediately before providing MAiD, the person has to be given the opportunity to withdraw their request, and the physician or nurse practitioner must ensure that the person gives express consent to MAiD. However, we do have two exceptions to this rule. The first is the final consent waiver. For this, to have a final consent waiver, you must meet all the eligibility criteria for MAiD. So you can't be early dementia before the advanced state of decline or before intolerable suffering has set in. It's not the advanced request regime of the Netherlands, for instance. Natural death has to have become reasonably foreseeable to be allowed to do a final consent waiver, and you must be at risk of losing capacity to consent to MAiD. If you meet those conditions, the patient and the provider can agree that MAiD will be provided on or before a specified date if the patient loses capacity before that day. And then if the patient loses capacity and they don't demonstrate resistance or refusal, MAiD can be provided under the authority of this final consent waiver. The second exception is for advanced consent for failed self-administration. So if the person meets all of the eligibility criteria, then you can have a written arrangement between the patient and the provider that the provider will be present at the time the person self-administers, and then they will administer meds to cause the person's death if, after self-administering, the person loses the capacity to consent to receiving MAiD, to an injection, and does not die within a specified period of time. So the final consent waiver, it prevents patients from dying earlier than they want to in order not to lose the opportunity for MAiD, because they're at risk of losing capacity. It saves life. Advanced consent for failed self-administration prevents patients lingering in a state they would not want to be in, which could be for a very long time, for a failed self-administration, if the failed self-administration takes too long or just fails. So that's the end of our interlude responding to things that came up yesterday. So the final piece is on where we are with our law. Clinicians have an obligation to report all requests for MAiD. Then the Federal Ministry of Health has a statutory responsibility for reporting annually to the Canadian people on the results of this monitoring. And some provinces also have additional oversight for MAiD through bodies that review all MAiD cases after the fact. And together, these actually represent 91.3% of all MAiD deaths in Canada. Also, Provincial-Territorial colleges of physicians and surgeons and colleges of nurses, they set the standards and they discipline for non-compliance for all clinical care, and MAiD is a form of clinical care. Clinicians in Canada do not have a duty to provide or assist in providing MAiD. In almost all provinces or territories, they do have a duty to make an effective referral to a willing and available clinician or a transfer of care for a patient who is seeking MAiD. It remains an open question whether publicly funded faith-based healthcare organizations are or even can be legally permitted to refuse to allow MAiD to be provided within their walls. Some provinces do not permit this, others are silent on the matter, and still others expressly permit it. Now, before moving on from law to practice, I just want to say a few words about what the future is potentially for MAiD law in Canada. There is a lot happening right now that may continue our values-based, human rights-driven journey with respect to MAiD. There is a charter challenge to the policies permitting publicly funded faith-based healthcare organizations to refuse to allow MAiD within their walls. That was launched in June. A charter challenge was launched to the exclusion from eligibility for people with mental illness as their sole underlying medical condition. That was launched in Ontario in August. Quebec has taken steps to ensure that its law that allows advance requests for MAiD in advance of loss of capacity, so it's written before all of the eligibility criteria are met, it's taken steps to make sure that can come into effect. Following directions from the Minister of Justice, the Director of Public Prosecutions issued prosecutorial charging guidelines to ensure that as of October 30th in Quebec, clinicians who follow the Quebec legislation and provide MAiD in compliance with the valid advance request, they will not be prosecuted for it, despite it being contrary to the criminal code. This is breaking news. The guidance came out on September 9th. So there will be advance requests in Quebec, but only in Quebec. And finally, there will soon be a charter challenge to the exclusion from eligibility of mature minors. That is, individuals who are under the age of majority, so under the 18 limit, but who nonetheless have the capacity to make decisions about MAiD. So that's the law. What you might be wondering is what's happening in practice. How much MAiD is going on, who's accessing MAiD, what are the reasons for requesting MAiD, and what are not reasons for requesting MAiD. Well, as of 2022, which is our latest published data, in 2022 there were 13,241 MAiD deaths. So there have been 44,598 since 2016. ChatGPT informed me that that means that there'll be 71,444 by the end of 2024. I would suggest that's an underestimate because our numbers are going up, and it calculated it based on 4.1% of all deaths being MAiD deaths. But that gives you a sense of the scale. And many, many more people benefit from MAiD being legal than actually end their lives through MAiD, because even those that don't access it are benefited. They get great comfort from knowing that it'll be available to them if they end up wanting it and are eligible. So who's accessing MAiD? Slightly more men than women access MAiD. The average age of those receiving MAiD is 77, with 85% being over the age of 65. Cancer is the most common underlying medical condition of those accessing MAiD, 63% of MAiD deaths. The most common aspects of suffering motivating requests for MAiD are the loss of the ability to engage in meaningful activities, the loss of the ability to perform activities of daily living, inadequate pain control or concern about that, loss of dignity, inadequate control of symptoms other than pain or concern about that, perceived burden on family, friends, or caregivers, and loss of control of bodily functions. I would note that these are reported on by providers, not by the patients directly, and they can select more than one, which is why the numbers add up to more than 100%. So those are the reasons for requesting MAiD. It's also essential to understand what are not reasons for requesting MAiD in Canada. MAiD is not being requested because of a lack of access to palliative care. Over 95% of those who received MAiD received or had access to palliative care. MAiD is not being requested because of a lack of access to disability support services. 98.9% of those who needed disability support services and received MAiD had received or had access to, if they wanted them, disability support services. Now, before closing, I want to dispel a few myths that are out there about what has been going on in Canada. I can tell you we are not, in fact, the dumpster fire that is being presented in the media. There is an expression that's particularly apt given the international nature of this conference, and that is that a lie can travel halfway around the world before the truth gets its boots on. Any lessons that can be drawn from the Canadian experience must not be premised on myths, and I give a few examples here. There are many more. Whoop, don't do that. So, Canada has careened down a slippery slope. No, it's false. The eligibility criteria for MAiD in 2024 is no broader than it was in the Supreme Court of Canada decision in Carter. And there is no evidence of individuals who do not meet the grievous and irremediable medical condition or voluntariness, competence, the eligibility criteria receiving MAiD. Canadians are getting MAiD for poverty and homelessness and other forms of socioeconomic vulnerability. This is false. It is not permissible to provide MAiD for poverty or other forms of socioeconomic vulnerability. Poverty is not an eligibility criterion for MAiD. Someone whose only complaint is poverty would not meet the eligibility criteria for MAiD. And there's no evidence of any cases in which a person has been provided with MAiD where eligibility was based on poverty. The same holds for other forms of socioeconomic vulnerability. In addition, there is strong evidence that socioeconomic vulnerability is not associated with higher rates of requests for MAiD. Indeed, the peer-reviewed empirical literature, as contrasted with media anecdotes, shows that at a population level, socioeconomic deprivation and service gaps appear statistically to be protective against, that is, inversely correlated with MAiD. Legalization has had a negative impact on palliative care, access, and funding. This is false. Funding for palliative care increased after MAiD became legal. Rates of palliative care increased after MAiD became legal. Clinicians are being forced to provide MAiD. That's just flat out false. Finally, let's ask when. Well, the answer for Canada was 2015, 2016. 2015, the Supreme Court of Canada decision in Carter. 2016, Carter came into effect, and we had Bill C-14. The answer for those with prohibitive regimes is, I hope, very soon. And so I'm going to end where I started with lines from a poem, only this time it's a brilliant poem rather than doggerel. And I would say that if we stay focused on values and on human rights, though lovers be lost, love shall not, and death shall have no dominion.